Awesome. I'll let folks in. I'm sure a lot more will join in the next few minutes.
Okay.
Good evening, everyone. Thank you so much for taking the time to join us this evening. Just wanted to set some ground rules before we get started. We'll be using the chat function to interact during this event. So if you have any questions, feel free to type them below and we'll answer them in the order that they come. The presentation will last for about 30 minutes or so. And after the presentation, we'll get to the questions for another 15 minutes. And to introduce our speaker today, Hendrik is the director of immigration strategy at Boundless. He has over 15 years experience in the field, and he has a range of accolades, both from the California Bar as well as the American Immigration Lawyers Association. So, for all the folks who are joining us today, you're hearing from one of the best. Thank you so much, Hendrik, for taking the time. And please get us started.
Absolutely. Thank you, Nick, and I appreciate it. And it's a pleasure chatting with folks today. So yes, let's see if, okay, that was the starting screen. All right, so yes, so today we're going to talk a lot today about kind of what's gone on in the immigration world since Friday. As many of you, I was kind of planning my weekend and looking forward to a lot of fun activities and with the family and Premier League soccer and all sorts of things I enjoy. And then Friday night, we kind of got this bombshell about essentially a travel entry ban for really all H-1B folks looking to enter the US. And so we'll kind of cover how this started. We will take a look at kind of where we are today in terms of what we know today about the H-1B and entries. We'll talk a little bit also about what we know about the gold card executive order. And then we will take a look at what we do not yet know and what we are hoping for more clarity on, as well as some suggestions for folks during this time of lack of clarity. And then we'll also talk a little bit about how folks can take control of the situation and feel a little bit more empowered in a time that can feel obviously very challenging. I will say that things are changing very quickly. So this is the information that we have at this point. So I'm just going to do kind of a survey. This is not legal advice. I would say before making any decisions, definitely speak with us at Boundless or an attorney, because again, things are changing very quickly here, and I don't want anybody to make any wrong decisions. So this is really informative in case there's things you have not yet heard about. And so we'll go from there. Okay, so let's start with just a timeline of events here. So there's a lot on this slide. We don't have to go word for word through it, and we will be happy to share the slides afterwards as well. And again, this will be obviously up to date based on today. But again, we started with the proclamation, which was really focused on limiting entry. It certainly is no coincidence that this was released on a Friday night. We've seen this before, effective 24 hours later, essentially, and lined up with the folks who on October 1st, new H-1B lottery recipients are able to enter 10 days before that. And this proclamation lined up pretty much exactly with that. And it was very clear that the intent was to limit entry into the US of all H-1B folks where there has not been a $100,000 fee paid. That's where we started. Obviously, behind the scenes, I'm sure there was a lot going on with a lot of companies upset and calling and questions and potential litigation. And so since then, there's been everything you see on the screen, and there's still kind of more coming out. So there's kind of a slew of tweets from the Trump administration's Rapid Response Unit. There were, there's CBP memos, USCIS memos. Everybody has their own set of FAQs, and unfortunately, a lot of this content is contradictory, which is causing a lot of challenges in deciphering really what's going on, who's safe to travel, who's safe to file applications, what the actual implications here might be. So again, we had the proclamation. A lot of what we'll talk about today is actually not even part of the proclamation, because we've kind of come so far in a few days with all this other information that's out there. And we'll take a look at some of the contradictions and why there's things that we do not yet know. So here you'll see summarized kind of the main points that came out of these different documents that, again, we'll get into a little bit more. I will note also that the reason that we'll talk about the gold card, and we have a section on this later, is this is something that's maybe is not getting as much attention because the H-1B entries is obviously such a huge deal. But we'll talk a little about the gold card because it potentially is just worth noting how it may interplay with EB1, EB2 categories, EB5 categories. And there's also been statements made by the Commerce Secretary that's not part of the executive order that can be a little bit jarring. So we'll talk about that and kind of what realistically is happening. So we'll keep going here. Okay, so let's take a look at what we actually know. So the for those who are interested, the proclamation itself really cites the power under Immigration Nationality Act 212F that's related to the power to restrict and control folks entering into the US. Now, I point this out because, as you'll see as we go, there's a lot of questions, and these memos talk about petitions, which is typically a filing with USCIS, when this is really grounded in controlling entry into the US. So that's a layer that has added to the confusion here. And so when I talk later about this memo saying any H-1B filing petition to the USCIS is impacted, that's where it becomes very difficult to decipher if they are actually using the terminology correctly. And so important to know the power that is being used here, whether correctly or incorrectly, and there will be litigation on all this, so all this might change, but is grounded in this ability to control entry. So that might be a little bit extra nerdy, but I think it's important to make that point. Okay, we also know that the current proclamation is set to be valid for 12 months, subject to extension. The proclamation was clearly aimed at folks entering on H-1B, in particular folks with a current this year's lottery. They have now said, it's aimed at next year's lottery, but will be valid for 12 years, and they could extend it for 12 years. So we'll talk a little bit more about that. We also know that the proclamation is not supposed to impact folks who had petitions approved or petitions filed before the 21st, regardless of if they still remain pending. So it seems like, I would say, do not travel unless you really have to, and if you do, talk to an attorney to make sure that you have the latest. But it seems that folks that had filings approved or filed before the 21st should be okay to get stamping. But I would say stay put for now. We expect more clarity to come out soon. There was a Department of State news alert that that essentially further kind of clarified this point. Okay. In terms of travel for individuals who have valid visa stamps and have a valid USCIS approval or I-94 notice, you should be okay to travel. Again, I would suggest not traveling at this point, but that is probably the closest to clarity that we have, is that folks should not have issue. We have had some clients, we've had reports from others as well, that in fact, folks have been successful in this particular situation, getting stamps We've also filed and seen others file extensions, things of that nature from within the US with USCIS, and they've been accepted. We'll talk about this later. Doesn't mean there may not be an RFE coming up. So again, we're kind of holding our breath, but so far there's been nothing. We haven't seen instances where folks have been made to pay this $100,000 fee. We'll talk about the fact that you can't even pay it today, even if you wanted to. Okay, again, this is aimed very specifically at the lottery next year, but it could also impact other H-1Bs, which we'll talk about, but we know there's clarity that that is their intention, again, if this survives litigation. And then change of status filings are subject to this rule. We'll talk about an exception that one of the memos talked about and whether that can be used. But yes, obviously lottery applicants will typically be change of status filings from OPT or STEM OPT, but also other change of status filings are likely impacted here as well. Okay, I'll turn quickly to what we know about the gold card and the implications there, because again, this is getting a little bit less attention, but I do think it's important to know. So, and you might think gold card, this is investor-based. Why are we talking about this? There's the EB-5 category already. You'll see in a minute why I'm including this here. This was the gold card executive order that came out also on Friday. And the goal here with this is to prioritize admission of individuals who will affirmatively benefit the nation, focus on successful entrepreneurs, investors, business persons who can provide this $1 million gift. And so that's specific language from the executive order itself. The idea is, again, $1 million gift, or employer or corporate entity can do a $2 million gift for an employee. So it talks kind of about some of those options. It says that there's a kind of a 90-day window within which agencies need to essentially set up this program, including establishing the process, specifying the date to apply, how corporations can go ahead and do this. And then the piece that they talk about in the executive order where EB-1 and NIW kind of come into this is that it seems, it's not very clearly written, but it seems to be saying that making this type of gift is going to count as evidence. It may be by itself sufficient evidence, or it may just be one of the additional pieces of evidence that can be submitted in these cases to show that an individual qualifies under EB-1A or an EB-2 NIW. Now, there is a lot of there's a lack of clarity there still, of course, because they just put this out. So it seems like that's the intention here, which would then mean that it also counts into the EB-1 and EB-2 quotas. And we'll talk a little bit about kind of some statements that were made about the green card numbers made available for this in a minute. They also talk about considering how to expand this into EB-5. So right now, it's not set up to be an EB-5 program. This is something separate. And that's where the EB-1 and NIW potentially comes into it. And then again, what needs to be clarified further is how will this impact backlogs? So as we'll take a look at in a minute, I think in the next slide, this is promoted as a quick way, a fast lane to get a green card, but it's likely still going to be subject to the EB-1, EB-2 backlogs. And so it's interesting how it's being positioned, but there's still a lot of there's still lack of clarity there, and how this is actually going to be implemented. And again, litigation, right? This is ripe for litigation. So essentially, this executive order is trying to change the criteria. If it turns out to be EB-1 NIW, it's potentially trying to change the way that the kind of impact quota and kind of green card numbers that are available. So this is obviously ripe for litigation, as is everything that we're talking about today. But this is kind of where we stand today. I will just make a note, again, to prove that it's still going to be part of the backlog. There's a website, Trump Card website, talking about this, saying you'll receive the residency in record time. Then it talks about a visa must be available. Then it talks about EB-1 or EB-2 as kind of the pathway here. So it's still going to be subject to that backlog. But again, I think it's important to bring up here because it could cause additional backlogs. And as we'll talk about later, it may be a reason to really focus on trying to get applications submitted if folks are kind of in the position to do that under EB1 or NIW. I will also just address one thing. That's all in the executive order. There were comments made by the Commerce Secretary that is really kind of scaring some people. So I want to address it, saying that this is really the way that these programs should work. It should be based on this type of gift. We should kind of rewrite the way that EB1, EB2, and other categories are granting green cards to individuals, and maybe we should pause all green card categories. And this should be the new way forward. Now, those are just statements that have been thrown out there. That's not in the executive order, and even the executive order itself is going to be litigated. So I just kind of wanted to address that because we have gotten several questions about that. We'll obviously kind of see where this goes, but I can tell you that there's litigation that will be filed soon on this. First on the H-1B entry, and then there will be litigation on this as well. Okay, so let's take a look then at what remains unclear. So if we're looking again at kind of the H-1B, and I'll kind of walk through here why things are still unclear. So it's really like, who else is considered subject to this $100,000 fee? So USCIS, White House have FAQs. That says, there's a comment in there that says it's this that fees required to accompany next year's lottery, folks, and any other H-1B petitions. Again, using petition when this is an entry ban is problematic in terms of the terminology. So the question is, does this include folks who are on H-1Bs now, filing extensions, having extensions filed, amendments filed, change of employers filed? Those are arguably any other H-1B petition outside of a lottery petition. But again, 212F controls entries. So why is it subject if you're filing with USCIS and you're in the US? Who would you even pay this fee to? Does everybody pay the fee to USCIS? You don't even know if someone's traveling. So there's a lot of questions there. USCIS then somewhat contradicted themselves between their FAQ and their memo and said that there's an exemption for folks with currently approved petitions. So meaning that if you already had an H-1B approval before the 21st or something pending and then it gets approved, and you then file a subsequent H-1B extension, amendment, change of status, seems like in that case, you should be okay. I can say anecdotally, the Boundless Legal Services team has been obviously just filing extensions after this. Those have been accepted. Will they be RFE'd? We will see. The hope is not, based on this and some other language, and we are making this argument in the filings, and so far so good, but it's been, 3 business days since this came out, so we will see. And then you have a White House statement saying that this rule is only going to apply to new visa applications. Visa application meaning not a filing with USCIS, but a request for a visa through Department of State. So you can start getting an idea of why there's so much yet to be understood and why we're looking for clarity, hopefully over the next week or two. There's also a comment here. Beneficiaries, again, like I said, of currently approved petitions should have an exemption here. So somebody, again, with an H-1B, USCIS approval, I-94, then there's a subsequent filing. The question is there, if you have never gotten an H-1B visa stamp, what's going to happen in that scenario? So you have a prior approved petition, but no visa stamp. Is that going to be an issue? That's another area that's not quite clear. And then again, are all these memos using the terms in the way that what it legally means, right? An extension is different from a renewal. Renewal's visa, extension is with USCIS. A petition's with the USCIS. A visa application is not with the USCIS. So there's a lot of a lot to untangle there, and that causes some of the confusion. So if we just quickly look at a hypo, we'll move on. So you have an employee that has an H-1B petition already approved. Again, filing extension, amendment, change of employer after the 21st. Under the USCIS memo, you may be fine because you had a currently approved petition on the date of the proclamation. Again, under White House and USCIS, it says any other H-1B petition is subject to the 100,000. Again, there have been cases filed receipted without the $100,000 payment being made. You can't even make the payment today. There's no process for it. But we'll see if we get RFEs. The hope is not. So the hope is that folks who already had petitions before the 21st or filed, subsequently file any other H-1B petition with USCIS should be fine. But we will still see. And then the question is what happens when you travel, right? Because that will then be an entry. And then the same scenario under CBP saying there's a memo saying that USCIS and the Department of State have been instructed to begin implementing this $100,000 fee on behalf of employees based outside the US for new H-1B petitions only. So that makes it sound like it's only applicable to folks who maybe have a consular processing application, they're based outside the US, and it's a new H-1B petition. So again, I am taking us into the eye of the storm here, and just to show the confusion that's happening. But anecdotally, cases with USCIS have been filed and accepted. And we'll talk a little bit about kind of how to navigate all of this. So even if subject, there is no way to pay the fee. We don't yet know if you pay the fees paid to USCIS. Is it paid to Department of State at the time of of going through consular processing for the visa? Is there a trigger if you mark consular processing on an I-129? And then again, just how do you pay this fee? How are they going to collect $100,000 fee on these cases? Because the credit card form is likely not going to work for that one. So a lot of open questions still. Hopefully over the next 2 weeks, a lot of this becomes clear also with filings that are being made and being accepted and then being approved, at least from within the US. And then we will wait for guidance for folks who then start traveling, hopefully once there's very clear guidance, to kind of see how visa stamping is being handled. Okay, and then again, we talked about the gold card impact potentially on EB1, EB2 quotas. That's still a big unknown as well. Okay, so we'll take a breath. I know that that's a lot, but how to prepare for this? So we've covered this a little bit. I would say restricting travel is the best thing you can do right now. It was very painful over the weekend with a lot of people having questions. And initially the advice was get back into the US right away, which caused so much panic and anxiety. And we felt so bad for so many people, and we were doing our best to help people navigate this. But that advice really still holds. If there is no really emergency need to travel, the recommendation from the legal team is do not travel. If you have a valid H-1B visa stamp, valid USCIS approval notice, if you must travel, then you will likely be okay. But these things are changing very quickly. Yes, so just things are changing quickly. I would say, the Boundless legal team's advice being provided to individuals and companies is that, if you don't have a valid H-1B visa, then really just wait for more guidance. There are a lot of people who, over the last few years, right, have changed status from OPT, STEM OPT to H-1B under the lottery. Maybe have never traveled and gotten a visa stamp. Had a H-1B approved prior to the 21st, but is this going to be seen as a new H-1B visa request and a new petition in the way that they're kind of incorrectly, it seems like, using this term? And will there be an issue coming back in? So yes, travel is probably best avoided. In terms of filing, and I know these are, employers as the petitioner filing these cases, but just to note, the legal team is making this argument in all filings that the filing is not subject to any of these, to the proclamation or any of the memos, because these are individuals who have already approved H-1B petitions. So this is not at all, this rule should not at all be implicated. Now, there's a few memos that kind of open that door and make that less clear, but just citing that, and again, anecdotally, these have been receipted and accepted. But this is so soon, we wouldn't even have RFEs yet on filings anyway. Worth noting that there are some other exemptions, so national interest exemptions mentioned here if it is decided that you're subject to this $100,000 payment. Now, we've seen this before with COVID and travel bans. There's never been a clear definition of what this means, national interest exemption. We don't know yet where you would be filing this. Would it be USCIS? Would it be to a consulate? There's no really clear guidance here, but it does mention that an exemption can be granted for an industry, for a company or an employer, or per individual case. And related to that, there's been news lately about physicians and medical residents as being examples of possible national interest exemption. So, again, there's not much clarity, not much guidance. We've had this national interest exemption, for before, and again, there wasn't much guidance, but we have been, we were successful in getting some of those accepted. So that's just worth noting. Okay, so all of that to say, some things are clear. There's still a lot that is either somewhat unclear. Cases have been accepted by USCIS, but not enough time has passed to see if they end up making some fuss via an RFE. We don't think so. And then there's still just the unknown of how some of these situations will play out once folks do travel and try to get like a first-time H-1B stamp, even though you've maybe held H-1B for a while. So a lot still unknown. Over the next 2 weeks, hopefully, there's a lot more clarity as cases work through the system and as there's additional memos, hopefully that unite everything that's out there and don't cause more confusion. But so beyond that, what can you do, right? So obviously there is working with, if you are an employee on an H-1B, closely with the company, HR, having, a counsel provide guidance there, checking in with them before doing any sort of traveling. What else can we do? So as folks probably know, H-1B and perm-based green card are kind of the traditional corporate immigration mainstays, right? And there's a lot of reasons for that. The kind of the downside of that, and H-1B and perm-based green cards are always going to be important, right? The downside of that is that H-1B is always in the crosshairs, right? This is not the first time. In addition to this, we have prevailing wage. We have prevailing wages that are likely they're going to attempt to increase prevailing wages. There is it looks like there's a new proposal to change the way that the lottery system will work based on wage level, really meaning level 1, level 2 roles will have 0 to very little chance of being selected. So, and we're going to continue seeing this in every administration with changes. If there's any changes or attacks, it's usually to H-1B. That's the most visible, and most people are on H-1Bs. So, and that's not a coincidence. That's the reason that these are always in the crosshairs. Same with the perm-based green card. Not only are things taking longer, there are audits on the way that recruitment's being handled. And then beyond that, for H-1B and perm, a lot of it is just out of everybody's hands, right? Whether it's political, whether it's the economy with perms not being able to get through recruitment when the job market is not doing well. And so, political, economic, within an organization, how is the organization doing? Are there layoffs that impact perm and then impact ability to stay on H-1B while H-1B is being attacked? So that's the kind of the traditional approach, H-1B and perm. So as individuals, what can we do? So and as companies, we talk to a lot of companies who are starting to kind of modernize their approach to diversify a little bit away from such heavy reliance on H-1B and perm. It's really to take control and position yourself in a way, whether you qualify today or at least knowing how close you are to O1, to an EB-1A, to an EB-2 national interest waiver. There's some other options as well, whether they're J1 related or kind of other options that can be discussed. But really, these three are the best, are really, I typically think the best way you can take some control. And And that includes getting, obviously, an assessment if you've never been assessed for these, or if you were assessed a while ago, getting a new assessment, understanding where you are on this journey to being qualified. If you are not there yet, understanding clearly what are the criteria to work on, what are opportunities to kind of help get that experience and that evidence as you work towards being kind of ready to file these types of applications. If you do that, that's something that you can do, and you can move yourself towards one of these categories. What then happens is you can then start advocating for yourself, right? So if you know that you are O1 qualified, now this can be perhaps your employer is supportive of helping you along this journey. That's not always the case. So you could get assessed, build towards this, and if you're confident and your legal team's confident that you are qualified for this, you could go talk to HR. We help people. We can also send some resources on kind of how to have these discussions. But talk to the HR. Say, look, the H-1B thing is really stressing me out. I'm not able to focus on the work that I want to do here. It obviously impacts my family. I can't travel. Like, there's all these things going on. I'm confident I'm O1 qualified. Will you sponsor? Will you file the O1? Will you support me in the filing of the O1? Whether through your counsel, whether through my counsel, there's various ways that this can be done, right? There's also flexibility on on who pays for parts of these applications, and an H-1B and perm, that's not the case. There's not that type of flexibility. So there's different ways to approach this. If you're working towards O1, you are, for the most part, working towards EB1 and NIW options at the same time. So that's great. You just have to keep going. You have to get more evidence, and it may take a little bit longer if you're not already qualified. But again, apart from you being able to, sponsor yourself under these categories, which is great, you could also have a conversation with HR. Maybe they will assist, whether that's internally to help, support the application, with letters of reference, with evidence of contributions that you've made. And if not, then this is something that you can obviously do on your own to not be stuck in this perm H-1B cycle. So, I think, again, a lot of people, more and more people have become aware of these options and that you are able to take control. But that would really be my suggestion, in addition, obviously, to staying on top of these things with your employer, with their legal counsel. You obviously can always also seek out your own individual counsel for a second opinion, or for information, or to just double check travel and things like that if you want that, as opposed to just what employer's counsel is providing. So some folks like to do that as well. But I think taking control here, and not being just kind of passive, and waiting for things to happen and for an administration to do certain things, to actually kind of start actioning some of this. So yes, so that is where I will stop talking. I'm sure everybody wants a little breather like I do, and maybe a glass of water. That was a lot to get through. But Nikin, if any individuals I haven't been tracking if there's questions or anything, but I'm happy to take some questions and follow up with this. We can follow up with the slides for folks later as well.
Thank you so much, Hendrik. It was such an informative presentation. And for those of you in attendance, we'll be sharing a copy of the slides. We'll be sharing a recording of this webinar too. So in case you missed something that Hendrik shared earlier, you'll be able to rewatch it again. And we have a ton of questions. For the attendees, again, please feel free to use the chat function to ask your questions. And if there are questions already in the chat, feel free to add a thumbs up or another emoji to highlight them so we can get to those questions first. Disha asked, I'm on H-1B cap exempt with valid visa stamp expiring next year and an approved I-140. I have travel plans for Canada end of this month. Is it safe to travel and return in a week?
Exempt expire next year. We are suggesting folks do not travel. So if you can avoid traveling, this is from our our Boundless Legal Services team and our kind of head attorney that's setting this across a lot of corporate clients and for individuals as well. At this point, we are advising, if you can stay put for a little longer, I would. Now, folks, probably the safest group of folks are folks who have a USCIS approval and a valid H-1B stamp. That should be the folks who are the safest. You don't need to get an additional. You don't need to ask for a visa. You haven't had any filing since the 21st. So you are likely in the safest group if I'm reading these facts correctly. But the suggestion is to hold tight if you can for us to just get a little bit more guidance. At least that is what our legal team is advising to our corporate accounts and employees. I will make one note that's also interesting is at least some folks are have Canadian citizenship, and so sometimes there aren't the same visa requirements. Even for those individuals, this is an entry bar. So even if there's no need for a visa for some folks from certain countries, it's still a little bit unclear. But yes, that's kind of the best recommendation at this point.
How about a related question to this, Hendrik, is how about for folks on STEM OPT or the OPT extension? Is it advisable for them to travel right now?
So this is only talking about H-1B petitions, H-1B renewals. This is going to folks on OPT who are looking at next year's lottery. Those folks, this is directly impacting individuals with those plans. So again, there's going to be litigation. We'll see where this ends up. The kind of unfortunate thing is that obviously the in terms of injunctions and things like that, I'm not an immigration litigator, but just across kind of the spectrum with the courts, it's been more difficult to have courts kind of grant nationwide injunctions on things. So it might not be as easy of to challenge this as possible as we would hope it to be. But there is going to be litigation comes out. But to answer the question, this is only about H-1B entry and travel and petitions. So folks who are looking at the lottery next year, this is directly going to impact those folks, but not folks traveling on other status types currently.
Thank you. Yash asked, does the 100K fee apply to people who are on F1 STEM OPT in the US and want to apply for H-1B for the same employer in 2026? And is it per petition, per candidate, or per company?
Yeah, so it's not an annual fee. It's per the petition. Now again, that's the latest word, and I don't know if that one was in a tweet or elsewhere if that was clarified. So rulemaking by tweet is not ideal. So we'll kind of hopefully get more clarity and see that. But yes, if this is F1 STEM OPT looking to be in the lottery next year with any employer, that's exactly who this fee will very directly impact.
Thank you. Manaswani asked, is there any news on STEM OPT being cancelled or controlled? And would that effect be seen retroactively?
So STEM OPT, work authorization, H-4 EAD, all of these things are talked about constantly, and in the first Trump administration as well, there were plans to kind of get rid of this. Right now, there is nothing there's nothing out there like a executive order or a proclamation. That's not to say it's these things aren't coming, unfortunately, right? So again, it's kind of this idea of taking control, because we'd be foolish to think that this is the last thing that's going to come out and throw us for a loop, and we're going to have to kind of figure out on the fly.
Sai asked, my H-1B was approved this year, but my employer plans to withdraw it before October 1st. Can I still preserve or recapture this approval for future use if I transfer after October 1st, or does the withdrawal cancel the chance?
Very technical question there. I would say that there's actually different, to some degree, some different opinions and different success that folks have seen in having typically, again, do not take this as legal advice from me and run with it. We need to speak. We'd happy to set up a call to get into this with you, with someone on our legal services team. But what we have often seen is, if it's not activated at all, then oftentimes you can't really preserve that. And there's arguments that you may have to enter it into that lottery again. Although I will say that I can say that I have seen or anecdotally heard about some success in prior administrations with still making an argument for this. So this is probably a little bit too technical to give an answer here, but I would say typically folks kind of activate it at least, and then are more successful in making some change to switch employers, for example. So yes, happy to take that call offline and give a more detailed response.
We'll send a follow-up email with a link to book a consultation. So that should be in all of your inboxes tomorrow. Kiran, moving on. Kiran asked, will the fee apply to people on cap-exempt H-1B visas who are changing employers or transferring their visa?
Yes. So there's nothing here that exempts cap exempt from this. So this is just H-1B fee. In fact, this could kind of hurt cap exempt employers even more, because typically like $100,000 fee, I mean, for any company, that's a massive sum. But a lot of cap exempt employers, it's just totally out of the question whether that can be supported. But yes, cap exempt, this would, as it's written today, it would be for cap exempt employers as well. And there may be, it may be cap exempt employers doing filings that will inform kind of the rest of us, because this is supposed to be for next year's lottery, but cap exempt folks, you can file the H-1B without the lottery. So those might come as like new H-1B applications sooner than other new H-1B applications. So we'll kind of see what happens there. I forget if there was another part of that question I missed, but about maybe transferring or something. But yeah, cap exempt is still arguably subject to this, and I would assume it applies. But yeah, again, as caveats to just follow up, because this may change, they may come out, but I don't see them not applying this to cap exempt.
Yeah. Kiran asked, how about NIW specialty occupations like physicians, semiconductors, and other similar occupations? That's the question, but just to rephrase it, are occupations that are subject to the national interest waiver exempt from the H-1B?
Yeah, great question. So this is the answer. There is language about national interest exemptions to this, just like there were under prior travel bans and the kind of the COVID era. There's never really been a clear definition of who is automatically exempted, but there were articles, for example, where they made statements about physicians as an example. So yes, if there is an argument to be made, and it seems like they could make a kind of a blanket exemption for an entire industry or an entire company or individuals in a particular role. So yes, those are, if there's going to be litigation soon, right? If depending on how that goes, either this is going to be less of an issue for the time being, or everybody's going to try to prepare for these national interest exemptions. And they're typically pretty difficult to get from what we've seen in the past, unfortunately. But could they make kind of blanket exemptions for physicians and for certain roles, for certain industries? Perhaps that would then be the hope. But the larger hope is that this becomes a very small issue in the future, but we will see.
Thank you. Drumal asks, is the wage-based petition going to be introduced for the H-1B filings from next year?
The wage-based petition. So maybe this is the new lottery for the
exactly.
For the lotteries. Yes, it seems like the goal is to have this be in effect for the next lottery. Again, we will see. This is all coming out like right now, so we'll kind of see. But this is proposed, and I would imagine that they're going to want to have this in place for next year's lottery to show that it's really level 3 and 4 that are being accepted, and they have this $100,000 payment. This would be the ideal world of the administration. They're adding money to the treasury, and they are limiting this to really level 3 or level 4 roles to keep salary levels high. I think that is what they are hoping for. Again, this has to pass some legal scrutiny in litigation, so we shall see. But that is the intention, I believe. Yes.
Shiva actually asked a very important question. If an H-1B consular petition is still pending, it's been applied this year, but it's for consular processing outside the US, do we still need to pay the 100K?
Yeah, so this is one of those scenarios where it's very unclear, because the argument is that this was filed before the 21st, so there's an exemption there, but this is a consular petition, so assuming the individual is outside the US. Now, that might not always be the case. It could be consular while in the US, and the intention is to go out. And so there's other language where this is really seems like exactly the type of case where they want the fee, but it was filed before the 21st. So I would think the hope is filed before the 21st makes this a non-issue in this situation. But this is one of the most unknown situations at this point, unfortunately. And maybe tomorrow we have clarity. So again, check in. We're making updates, so you get access to kind of what we're providing. But I would say certainly keep getting updates and speak to legal counsel, because that's a great question. I wish I had answers, but that's a great question.
Yeah. Rowan asked a question, and I'll just slightly rephrase it, which is, could you comment on adjustment of status from F1 to H-1B? Will there be any effect on it?
Yes, I mean, whether this is for cap exempt or whether this is for next year's lottery, this is exactly what they're looking to target. Now, folks that filed before the 21st of this year for this year's lottery should not have an issue per the guidance. But it is exactly the change of status to H-1B, especially first time, and if you've never had an H-1B visa stamp, if you've never had an H-1B at all. There's obviously questions. If I had an H-1B a while ago and now I'm filing again for an H-1B, can I use that to say I had a prior H-1B? Like, these are all the edge cases that we will have to work through. But that situation is, for everything out there, exactly what they are looking to target. For next year, for sure, if this holds up. For this year, if it was filed before the 21st, that's the best argument against it applying.
Yep. Perhaps this is a simple, silly question, but I think it's important to clarify for the audience. Is there any fee applicable for folks on STEM OPT, or is this fee only for H-1B?
Yeah, it's only been focused on H-1B. Now it is a good question, because there's a lot of information floating around about other things, but this is focused on H-1B solely. So it's really when you move to an H-1B, then these fees apply potentially.
Disha asked again, when will these litigations be filed, and how long will these take?
Yeah, great question. I am very familiar with some litigation that is coming. And there would have been litigation in my conversations with folks who are kind of engaged in doing this, would have been already filed, but for some of the clarifications that were that have come out since the proclamation. Now, these suits will likely be filed over the next few weeks, is kind of the estimate here. The hope would be, and again, I'm not a litigation expert, but the hope is, along with the filing, there's a request to stop this from going into effect until there's an actual, a decision on the merits of the case. Now, that has become harder in the legal sphere over the last few years to get that type of nationwide injunction. But that would be kind of the hope, that this cannot go into effect until this is actually litigated. But yes, the litigation is coming very soon, and probably starting with this entry band. There is, it's always a challenge to find a group of plaintiffs willing to put their name on this type of litigation. So a lot of times that is really, you would think it's easy, but it's not always easy, for reasons that folks are putting their name out there, right? You want, you want to have the, kind of the right plaintiffs who can show the right type of harm, and you want them to kind of step up and help do this. So that sometimes, I'm not saying that's causing delays here, just that is just kind of another nuance to this. But yes, my guess would be over the next couple weeks.
Thank you. Santosh asked, will there be any effect on the perm process, such as like the PWD? Will they be impacted?
Yeah, so there's nothing specific, at least as far as I know. I've been kind of swamped with a lot of stuff the last few days, but to my knowledge, there's nothing focused on the actual perm process. Prevailing wage changes to the prevailing wage scheme itself, and if the actual Department of Labor prevailing wage levels change, that's going to have that's going to have an impact in terms of those wages. The company's having to show that they can pay those wages across all the perms that they filed. So there's an impact there, but there's no $100,000 fee linked to any part of the perm or I-140 process. Really, the closest kind of interplay here is, you obviously need to get through the perm process to continue the H-1B beyond the 6-year maximum, but there's nothing about the fee itself that should impact perm processing. If this $100,000 fee sticks, I can say that's going to obviously have a major impact on companies sponsoring folks and the level to which they sponsor folks, and how those immigration programs and benefits change, and willingness to sponsor and to file perm applications. It's hard to know kind of the size of the impact here, but we will hopefully not have to deal with that with litigation that's coming. We'll see, but it's a good question, but nothing directly perm and that ties perm to $100,000 fee.
Ashwin asked, if you have an approved I-140 and if you're filing H-1B extensions, are you subject to the fee? I'm kind of rephrasing here, but
yeah,
please expand.
Yeah, that's some language in some of the memo or FAQs would say any H-1B petition is subject. Petition, that means USCIS filing. Now, that doesn't make sense, but it's in there because this proclamation is based on limiting entry. USCIS filing has nothing to do with getting a visa and entering, but there is language there that gives us pause. So there's not a definitive answer on this yet. I can say this is the same as folks who have approved H-1Bs, and that we're filing extensions for those folks. They are being received by USCIS and accepted without these fees being paid. Again, this has been 3 days. We don't know if an RFE is going to be issued, but the hope is that those memos that just have incorrect language in them, and that folks who have had H-1B, at least for filings with USCIS, will be okay and will not have to pay the fee, is the hope. I cannot say 100% that's the case. And it's going to be more limited to when you travel, and if you need a visa stamp, what happens at that point. So the hope is, and I think there's a good chance that those extensions will continue, or amendments will continue to be accepted without having the fee, but we need to wait for more clarity. So I can't definitively say yes or no on that.
Swati asked, how do the qualification criteria for gold card visas compare with the EB-1A?
The criteria for gold card compared to EB-1A. So the gold card, it's interesting that gold card is an executive order. The H-1B entry is a proclamation, which it's unclear why they did that, and if there's some litigation strategy there, or is it just, I don't know, we'll call it this and we'll call it that. I don't know. But it's interesting to note. the gold card executive order is really saying, if you can gift $1 million, you must be amazing, is essentially what it's saying. And it's saying if you have $1 million to gift to the US Treasury, then that is either, it's unclear, you can submit that as part of your evidence to show you satisfy as extraordinary ability under EB1A, or that you should get a national interest waiver. So it seems like it's saying that is an additional piece of evidence that either will just automatically get you approval, or it will be very strong evidence in addition to showing some other criteria. That's unclear. So, but the criteria itself is, at least how it's framed now, there's like there's like a menu. It's like a product offering. If you go to the Trump card website, it's like the platinum, gold. It's like a credit card you're applying for, and it's like benefits you get. But it's like if you can gift $1 million, and you submit an application, and I think they vet you first and then give you the go ahead. Then you have to transfer the $1 million, and then you can apply and get your EB1, EB2. That's kind of like how it's laid out at this point, with no real clarity on the actual process. But within 90 days, they're supposed to come out with clarity there. There's also an option for a company to pay $2 million. Seems like per employee, but they can switch that to a different employee if they don't want to sponsor that employee. It's very unclear, but it's a pretty short executive order. So I wouldn't say it's a fun read at all, but it's, you can take a look and you can see there's not that much in there at this point.
Thank you. Rami asked, is the O1 the only option left for students with no prior H-1B?
I wouldn't say it's the only option. I mean, this assumes, there's no TN or H-1B1 or things of that nature. There is there are some other options like J1. There's kind of some other options to consider. These typically need need employer sponsorship, and this is something that we are currently trying to figure out for companies to kind of open up their programs beyond H-1B and perm, because this is not the last time this is going to happen. And so we need to diversify risk across more immigration options here. And so that is something that we are actively working with kind of, corporate folks. But yes, there's a couple of, so J1 is one example of another option. And O1, if you've just graduated with a bachelor's degree, it's challenging. I mean, you can work towards it, but it's not going to immediately happen, right? Now, folks with graduate degrees, maybe that's much closer. Maybe you're already qualified. So it's really case specific. But O1 is the ideal, typically. I don't say it for everybody, but typically O1 is the ideal alternative, or just the ideal, with the H-1B the alternative, I would argue. But O1, H-1B, maybe J1. Some folks have TN, E3, H-1B1, but that's very rare. But yes, there's unfortunately not, an endless alphabet soup of these that we can use.
Thank you, Hendrik. And we are almost at time. This question has been uploaded a few times, so I'll kind of ask it again, which is, Soham asked, will the $100,000 fee be applicable to future transfer of employers?
Yes, this is one of the open questions. So this is like a change of employer filing. So again, the best argument that it should not is, before the 21st, I held an approved H-1B. This should not apply to me. Any subsequent filing, you make that argument. I had an approved H-1B or something filed before the 21st. I'm exempt from this rule per. Make sure you pick the memo that actually uses the language, right? The language that we think is correct and not the wrong one, because the wrong one says any H-1B petition. It says 2026 lottery and any H-1B petition after the 21st, which is not what we want. But I think that one is just, my hope is that one's just incorrect. But yes, it's a little bit unclear still. again, these cases are being accepted. We'll see. We'll have a lot more clarity in like 3 weeks, hopefully from guidance and just from cases that are being filed with USCIS. See if there's RFEs on these. Hope so. Hopefully, okay. Still a little bit of an open question. I know that's a terrible answer, but that's really the best I can do based on what we know today. And please, this might all change tomorrow. So stay up to date. As Nikin said, we will make ourselves available, share information. This is going to change many more times. So what we talked about today, don't wake up tomorrow assuming a word that I said is accurate or correct or legal advice in any way, because we just don't know what's going to happen tomorrow. So hopefully this just brings people up to speed on where we are today.
Thank you so much, Hendrik, for an insightful presentation and for taking so many of the attendees' questions. And to all of you who made it today, appreciate you for taking the time. We'll be sharing the recording, a copy of the slides on email. We'll also be sharing a way to schedule a one-on-one consultation so you can find out if you're eligible for these different visas or if you have other questions as well. And finally, if you have any further questions that you'd like to get answered async, we are available on email as well. So we'll follow up with all of this tomorrow. And these are a bit of uncertain times, but if there's something that defines immigrants, it's grit and tenacity. So we're here as a resource, and similar to other challenges we have encountered, we'll be able to see this one through as well. Thank you all so much. Have a great week and see you all soon.